Welcome to the Binary Agora. I'm your host, Alba Rivera Martinez, and today, to commemorate the nearly 1,000 downloads of my paper, Generative AI in Checked, Gatekeeper Power and Policy under the DMA, I wanted to recap what has happened with regards to the interplay between DMA, how its enforcement is going to take place, and with regards to the integration by gatekeepers to AI features and AI services that they have been launching for some time now. As always, I'll include all of the papers, all of the references I will make in the comments below, and do not forget to subscribe, like, and rate this video. Within that paper that I authored more than 2 years ago, I first thought about how AI was going at the time to interplay with the DMA and how the European Commission was going to assume that challenge. And within the paper, I basically sketched out 3 policy options that the European Commission could take into account in order to integrate AI into its enforcement. The first one was to add a new CPS in the form of an AI service or LLMs more broadly. Then the second policy option was to designate some of the already existing CPSs for instance, voice assistants or cloud computing services. And the last policy option related to this analysis that the European Commission could perform with regards to those embedded functionalities and features that lie within the gatekeepers services already. And back then, we did not know so much about AI. We knew about chatbots. So, for instance, it was the time where ChatGPT spiked in terms of its user adoption, and regulators were worried in terms of what impacts could that have on the market. However, I would say that 2 years on, the situation and the scenario has really changed, and now we are facing really profound transformations from the gatekeeper services as stemming from their integration with AI features and AI functionalities. Within the paper, I also defined this idea that we must, at every single time that we face a challenge of any type, we must address it through regulation. For instance, with the particular case of AI, we do not have sufficient economic evidence and economic backing to really justify that regulatory intervention is needed, specifically because we do not really know whether there are low levels of contestability within these markets. We also have not really defined what those markets look like. It's not the same to observe a chatbot versus the integration of AI within a social network or the tying of a chatbot within a messenger service. So I would say that we do not quite know how to define those markets, what their characteristics are. We cannot really capture a phenomenon that we have not really defined, first of all. I think that the paper was more of an if. So what if the European Commission intervenes in this particular space, so the AI space? But now, 2 years on, we have moved forward towards assuming that it's not a matter of if, but rather a matter of how, when, and what will take form with regards to the European Commission's regulatory enforcement of AI through the DMA. So the research question has really transformed since then, and now we are already seeing that the European Commission has really integrated the AI rationale in its enforcement, and now it is substantially engaging with AI on its own merits. For instance, we have many examples of that. The European Commission has now proposed draft implementation measures relating to Google's interoperability with AI features. So now the European Commission is going to force, under Article 6.7, Google to open up its AI features so that other voice assistants and AI assistants competitors can enter the Android OS on an equal footing with regards to its functionality and for instance, the latency by which these features can function relying on the OS. We have also seen the European Commission's draft implementation measures with regards to the specification proceeding relating to the access that Google must render to competitors in the online search engine market to its own search data. I think it's paragraphs 1 and 2 of those draft implementation measures. The European Commission already highlighted that the definition of those online search engine providers can be broadened to include chatbots. It's not that the European Commission has recognized that, for instance, AI overviews must be designated as a standalone service, but rather the reverse, so that chatbot providers, ChatGPT, Perplexity, may have the possibilities that other traditional online search engine providers such as DuckDuckGo or Ecosia may also benefit from the opportunities opened up by Article 611 of the DMA. This seems like a monographic of Google, but the European Commission's enforcement is steering that way. Now we are also waiting for the European Commission's decision relating to its non-compliance procedure against Google search and how it is going to interpret the self-preferencing prohibition under Article 6.5, and those general principles might also apply to AI overview. So I think we can move forward from what we were talking about at the start of the discussion with regards to what is going to happen with AI. Is AI going to enter the door of the DMA? Well, it has opened that door, and the European Commission is transitioning towards a different regulatory strategy, a different enforcement strategy, and now it has before its own eyes an undeniable transformation of the market that it cannot ignore. It's not only that the European Commission's enforcement strategy has changed, but rather that the market has changed. So as opposed to 2 years ago or 3 years ago, we saw that, okay, there were the spikes in user adoption with regards to chatbots, but AI was not integrated as transversally as it is today within Gatekeeper services. So for instance, one of the main developments that will crystallize with regards to how AI is integrated relates to AI agents. So this capacity of LLMs to interact with your own devices to perform tasks. And as a matter of fact, the European Commission, within its 6.7 specification proceedings addressed to Google, it has already provided that competitors must be able to, in that sense, imitate some of the tasks, for instance, of completing a booking or a hotel accommodation, as Google can already do through its own AI agent-like features on OS. We have also seen that gatekeepers are indeed feeding their LLMs and their AI functionalities and features through both personal and non-personal data of their users within their CPSs. The most salient example of this is Facebook's and Instagram's scraping of user data on those social networks so as to feed all of that data into Meta's LLMs, Llama, so that it functions more effectively. It really defies the idea of Article 5.2, which is basically to prohibit any data combination across core platform services relating to personal data. And I think that this is an unresolved question that the European Commission must engage with as soon as possible. But we have already seen that not only public enforcement, but rather private enforcement has a role to play here. A regional court in Germany already issued a response to request for interim measures, basically interpreting Article 5.2 by saying that combinations of data that happen across non-identifiable profiles of people are not to be comprised under the scope of Article 5.2, which is basically interpreting Article 5.2 in a completely different way as the EU legislator initially thought of. On top of that, it's not only that Article 5.2 is applying and should apply to AI services, AI features, AI functionalities embedded within the gatekeepers' services, but rather other data-related obligations within the DMA are at the heart of what the EU legislator was expecting for the DMA to deliver. For instance, I can think of Article 6.2. So Article 6.2 mandates the siloing of business user data so that the gatekeeper cannot use that business user data to compete with its business users. And I think that that is also a key provision with regards to online intermediation services and how they treat and process data with regards to the competitive advantage that it can provide for them, stemming from the data that business users may produce when they interact with an LLM or when they build their own tools as stemming from an AI-powered tool. We have already We talked about AI agents, feeding of data for AI purposes, and the last one is one of the most salient topics of the channel right now is the transformation of search. A few years ago, you looked up for a particular query within Google and the blue links appeared on the SERP, and you clicked on what you thought was more attention grabbing. That had really transformed with Google's introduction of AI overviews, which is basically this window that is shown at the top of the search page where Google tries to resolve all queries posed by its users by providing a more accurate answer as opposed to the users browsing the web through the blue links. So here we have one of the most consequential transitions that AI has been introducing with regards to search specifically, because now users do not interact with search as they used to. So users now address Google search using mainly questions rather than strings of words or sentences. And user behavior has also been altered as a consequence, as opposed to the many links that user could click so as to get to an accurate response to their query. Now it seems that the Google search experience is transforming towards a zero-click experience. That is, the user types a query on Google search, and now those users are quite satisfied with the answer provided by AI overviews at the top of the page, so they don't even have the need to go through all of the links listed below, regardless from the fact that the ranking of those links might not be completely fair, as the European Commission is currently analyzing. On that front, this is quite a profound transformation for two reasons. So the first one is, and this is something that we will cover in the channel quite soon, so regional court also in Germany has decided and ruled that Google cannot hide behind the fact that LLMs are not deterministic, but rather they are probabilistic tools, and it cannot hide itself behind the fact that LLMs get things wrong. So that AI overviews should work in a more deterministic way, so as to provide accurate and correct answers to the queries, to the questions that the users insert within Google search. So that's the first one. And the second one is the potential impacts on outcomes that we have already seen throughout many episodes on the channel. I will also link the list with all of the AI overviews analysis that we have performed here on the channel. But the main point of contention that I really perceive from how AI overviews is going to evolve within this profound transformation of search is basically what type of answer is delivered. So first, do we want AI overviews to deliver accurate results, deliver the result that link maybe in page 10 would provide, or do we want the queries on Google to be answered according to popularity? The AI overview should not list the answer that would be included within a web page listed in page 10, but rather the most popular content that would be ranked first within the prior Google search experience. So that's the main tension that exists there. And there's a third option that we must also contemplate, which is basically that Google, now, for instance, ChatGPT is already doing that. Google may also engage in marketing campaigns and selling basically its AI overviews space for some strings of keywords. And it may well be the case that particular answers to AI overviews to the search query are not answered, bearing in mind the most accurate result or the most popular result, but rather the branded content that Google agreed to deliver in a particular scenario. So I think that it's also a question of the level of trust that users are relying on when navigating the web, and this can be translated therefore to what fairness in the sense of the DMA means when search results are delivered. The question would then be, if for instance we go for the second option, so the most popular answer is delivered on AI overviews, does that mean then that the particular web publisher who would be ranked first within Google search, gets its content basically scraped from the web, so no clicks result within its website, but its content gets listed within AI overviews. Is that a fair outcome? Or rather, we as society want regulators to intervene within this type of business model and determine how AI overviews should deliver results. So maybe we do not want AI overviews to be flooded with branded content because that's not useful for society. But on the other side, if there is a majority of branded content listed on AI overviews, web publishers will have a better chance to compete because, as we saw with the use of widgets or branded content on Google search in the past few years, users can get really used to seeing that branded content, seeing that it's branded so that it has no quote unquote relevance for the user, so that the user is therefore forced to again navigate through the blue links that have been traditionally displayed throughout the regular user experience. These are the main transformations that we have seen with regards to market outcomes. And going back to the broader questions of how the European Commission is tackling these challenges, the European Commission is basically answering within the three policy options that the paper posed: the addition of a CPS, the new designation decisions based on the CPSs of virtual assistants and cloud computing services, or rather the embedding of these AI features within the CPSs as a policy option to adopt with no need to introduce an amendment. The European Commission has basically decided in favor of the latter. And this in turn poses some problems, because now the European Commission must face the music of saying, do all provisions within the DMA therefore automatically apply to these embedded features? So, okay, we agree, for instance, that the combinations of data from Facebook and Instagram to its LLM must abide by Article 5.2. But by the same token, must the integration of Amazon on its marketplace of its AI tools, for instance, Rufus, which is basically an assistant with regards to shopping, must Rufus also comply with the legal principles that the European Commission outlined within Amazon Buy Box with regards to Article 6.2, so the siloing of business user data? Is that how is it going to work? AI overviews, if it is an embedded feature within Google's search engine, then it serves the same purpose, so that we must find it accountable for provisions like Article 611, so that competitors must also have access on the data generated by AI overviews so as to integrate or replicate that on their own business models. And with regards to not so popular provisions and mandates from the perspective of the European Commission, such as 612, which mandates the fair, non-discriminatory and reasonable terms and conditions of access that gatekeepers must render with regards to search engines. So how would that take form with regards to AI overviews? I believe that, as ever, the solution and the answer to this question is a bit more nuanced than adopting a black and white solution. I believe that the European Commission can both analyze some AI features as embedded functionality within the existing CPSs, but once the purpose of those CPSs is exceeded and surpassed, now we must think about designating or delineating additional services, or rather carving out those services from the DMA. This is something that the European Commission has already done with other designation decisions. So now the European Commission must say whether it can have both things at the same time, and I think it can. So first, the embedded functionality, and then whether LLMs can be defined as a new CPS if that amendment finally fructifies, and how it is going to define that purpose of the LLM, and whether it can also be set apart from the existing CPSs. So it's not only that we make this choice on do we add a new CPS to the list of Article 2 or we don't. We have to think about how that definition would take form and how the European Commission would have enough of leeway to try to delineate that particular definition, so the LLM definition of a new CPS with regards to the existing CPSs. And I think that this is going to prove difficult for the enforcer, bearing in mind that many LLMs are not only one thing when applied to different contexts. They are more of a tool rather than a specific service rendered to the user. So, for instance, we are already seeing that chatbots can be many different things and can serve many different purposes. So I believe that the European Commission, the European Parliament, the Council, if they in the end work on this amendment, will have to really reflect on what added value would the addition of a new CPS bring to the table. And to end this brief talk on this interplay between DMA and AI, even if we resolve all of the problems relating to adding a new CPS within this multi-purpose scenario, we must also think about the actual requirements that the European Commission must fulfill so as to designate an undertaking or a CPS and characterize it as a gatekeeper. And in this particular sense, it does not seem that LLMs can be equated with what the DMA within Article 3.1b says that an undertaking must be to become a gatekeeper, which is an important gateway for business users to reach end users. So as of now, if we look LLMs within a snapshot picture right now, we do not have that intermediation between different types of users. So it's true that chatbots deliver for end users, but we do not have that middleware that intermediates the business of competitors with regards to end users. So that's a main challenge to bear in mind with regards to all of this discussion that we are already having with regards to the integration of AI in the European Commission's enforcement. And with that, I invite you to comment on the video if you agree, disagree with me, and I expect to see you on the next video. So thank you so much for joining today. See you on the next one.